Hi, good morning and coming to afternoon, everyone, well, wherever you are. Thanks for joining this particular webinar. Today's topic, discussed, and this is hosted by the Blockchain Association of Singapore, is actually on the new Omnibus law, right? So that is coming up, and I think this is something that either you are very curious about it or you are actually pretty jittery about it. So I think today's session is a group of professionals, right, in this space for a pretty number of years, and to besides talking about what exactly this is about, at the same time you'll be going through various opinions on what it should be like before talking about the response to MES. We have a couple of poll questions. Feel free to answer those so that we know exactly your your sentiments and all that. We will be bringing this consolidated, I would say curated response to MES so that they know what the industry is feeling like, right? So besides the the feeling sentiments, we will be also compiling questions that you may have. Feel free to ask those in the Q&A. We will be documenting all this down and then kind of compiling them before massaging it and engaging MES with the official response coming from the association, and as well as the feedback coming from the public like yourself, right? So how it's going to work today is that I've done the introduction. We are also going to talk about the launch officially of the regulatory in compliance chapter within the Blockchain Association of Singapore. This is the second chapter, right? Or rather subcommittee as we call it right now. The first subcommittee was actually the Digital Exchange subcommittee that was actually comprising of major exchanges around the world, and especially those are based in Singapore. This is the second one. The first one is based on the concerns about operations as well as like the regulations for these exchanges. Here today, we are talking about compliance to the new Omnibus regulations that's coming by MES. So this is something that it actually will impact everyone, as I think the team here will explain later on, as well as like I think many concerns about it, right? So without further ado, I shall talk about the launch of this particular subcommittee. It's going to be chaired by none other than Nizam Ismail. For those who are actually in financial services in Singapore, you are no stranger to him. He's ex-MAS. So he'll be leading this particular subcommittee. Now, in this subcommittee, we also have Chai Kit from Synosis. I guess for those who have actually applied for the PSA, you'll be probably having Synosis in your applications for the license because of the AMKYC program. Then we also have Mason from iStocks. So Mason is actually, her background was actually ex-MES as well, right? And she's now currently in iStock, one of the first regulated RMA exchanges for dealing in security tokens. And then we have also in the ExCo Asman Hamid from Upbit Exchange. He's besides being the Digital Exchange subcommittee, he's also in this exchange because he's the head of compliance for Upbit, right? These are all the ExCo members. Coming up, there'll be a few other inclusive members as well, right? And then, of course, on the panel today, besides all those who are in the ExCo, we also have Robin Lee from Napier, right? Robin is in this space for a bit of time, right? Very earlier on in financial services, especially he's having a very special role. He's actually a representative of the US Department of Justice, right? So he's actually working for the CIA. That's a joke. Yeah, so he's here to share his knowing about internationally how these laws are actually working out, right? So I think without further ado, I shall hand over to the introduction to Nizam to explain what is this law about. I think all of us are still a bit puzzled, right? What does it mean for us? What is it about? How does it impact us? So let's have that happen to introduce to you about law. Then eventually, once that's finished, we will actually proceed with the panel of discussion where we had the opinions from the industrial leaders in the panel today. Thank you.
Thanks, Kevin, and very good morning, everybody. Welcome to this inaugural session hosted by the inaugural Regulatory and Compliance Subcommittee. So we're very thrilled to be part of this historical process. The world being what it is right now, virtual meetings are de rigueur. It's not ideal the way that we typically would like to handle this because we used to host roundtables, which was very interactive, but nonetheless, it is what it is. So we're going to tap on your thoughts by some very quick poll questions interspersed in our presentation. And we are also going to tap on the wisdom of my colleagues in the Regulatory and Compliance Subcommittee with their wealth of experience. Okay, so how this works is that I'm going to take you through some of the key proposals in the MASCP consultation paper. And then also, there are certain questions, signpost questions put forth by the MES. I will ask one of the panel members for some of the questions. But, okay, Kevin, you're jumping the gun, but never mind, the poll questions are up. So this is a warm-up just to get a sense of why you guys are here. So why are you here attending today's session? Whether you're a regulated FI, you're applying for a license, none of the above, you're a concerned person. There should be an option D that you're actually a groupie and you like one of us. But let's ignore that. So let's shoot and see what your responses are. Kevin, you can share the poll responses once it's done. You got that? You're on mute, Kevin.
Okay, we'll do. I think we are waiting for 100% voting, but I think let's say in 1 minute's time, which is soon. So, in view of time. Okay, we are ended. So we're going to share the results.
Okay.
Can you see the results?
A lot of you guys are actually regulated space, almost 50%. So that's pretty interesting. Okay. Okay, I'm going to share my screen right now and jump into the presentation. Okay, I hope you all can see this. Okay, so judging by the absence of lost looking faces, I assume everybody can see this. So let me just kick off. So these are our esteemed panel members in their more glamorous shots. Okay, there are three realities in life, like it or not. One is death, nothing we can do about that. Second is taxes, you just have to pay them. And third is more regulations. Again, nothing much you can do about that, especially half of the audience are going to be regulated. And the other reality, which is not here, is that financial services is the most heavily regulated industry in the world. And if you look at the, I actually keep track of the number of consultation papers issued by the MES over the years. That's on average 17 CPs a year, which is actually quite crazy. That means, you know, within 1 month, you get 1.5 CP on average. That's a lot. And of course, not everything is going to apply to you, but you still need to know what's going on in order to assess whether or not it applies to you. And some of the CPs could be very substantial and you know, have got multiple prongs of impact on you. So if you haven't subscribed to the MES website, please do so, especially for the CPs. Now, okay, we've done poll question number 1. So just to understand what the Omnibus Act is, okay, so, you know, we've got this multitude of legislation administered by the MES, right? So there's the MES Act, which technically doesn't impact people as much because it's got a lot of very generic provisions. And then you've got the real substantive acts like the Banking Act, Insurance Act, the Securities and Futures Act, Financial Advisors Act, Payment Services Act, recently enacted, causing a lot of grief to everybody, Trust Companies Act, and the Business Trust Act. Now, the Omnibus Act doesn't, the good news is that the Omnibus Act doesn't impact on most of these acts, except peripherally. We can discuss that in a bit. It's meant to impact some of the provisions relating to MES's supervisory powers, which are now contained in the MES Act, into this new legislation. And there are a couple of areas which we will go through in a bit. One is prohibition orders. So that's one key area. The next is another major area, which is Singapore. VASP stands for Virtual Asset Service Providers, or you can loosely call them cryptocurrency intermediaries or businesses that actually conduct business wholly outside Singapore. So that's quite important. It doesn't cover VASPs conducting business within Singapore because that's already covered by the Payment Services Act. So we're really talking about VASPs, which may be incorporated or physically located in Singapore, but doing business outside of Singapore. Okay, the next is in relation to technology risk management. Okay, it's not meant to introduce new rules for TRM, but it's, the idea is to introduce a maximum penalty of $1 million. So we'll debate about whether it is appropriate in a bit. Last, there is a statutory protection clause for employees or officers or adjudicators or mediators under approved dispute resolution schemes in Singapore. So, I mean, the first impression you will notice is that this is quite a hodgepodge of very different set of issues. So I think when the panel was looking at the Omnibus Act to begin with, the immediate impression was that it looks like, where are we really going through? So you can talk about the theme of the Act, but I think the rationale of these various provisions we will go through in a bit. Okay, I'll just move on. Okay, let's start with prohibition orders. Now, the effect of a prohibition order is to prohibit persons from doing certain activities, regulated activities, but that is being expanded, so we'll get to that in a bit, or hold key positions in financial institutions. It actually started with the Securities Futures Act and the Financial Advisors Act and the Insurance Act. Now, for these legislation, particularly the SFA and the FAA, you remember that there is a concept of individual licensing initially, and then they've moved to the concept of representative notification regime, meaning that there are two layers of licenses being granted by the MES, one at the institutional level and the other at the individual level. And MES plays a gatekeeper role in only admitting fit and proper persons, whether you're the corporation or your individuals, to be able to conduct regulated activities. Now, the issue right now is that there is a gap because other than the three legislation, the MES cannot currently issue POs for activities other than the above. So technically, there are no POs that can be issued, let's say, under the Banking Act, right? So the proposal is by the MES right now is to broaden the scope of persons that can be subject to prohibition orders. It rationalizes the grounds for issuing the prohibition orders. In essence, it makes it easier for the POs to be issued. So we'll get to that in a bit. And it widened the scope of activities that are prohibited. Again, we can debate about that because that I think deserves some discussion. The MES argues this is similar to the approach in the UK and Australia. It assures that it will take a risk proportionate approach depending on the severity of the misconduct and the impact to the financial services sector, and you have a right of appeal to the minister. I've actually done one of these appeals. It's actually quite an interesting process. Okay, let's move on. Now, under the current regime for the SFA and the FAA, the approach is that only persons conducting regulated activities. So for instance, if you're dealing in capital markets product, or if you're an FA, you're doing financial advisory activities, you can be subject to a PO because, to begin with, you need a license to conduct those activities. Now, here's the proposal. The MES wants to widen this beyond just regulated persons. So they want to widen this to include a concept of people who can potentially cause harm to the financial institution. And this could be people in any of these three buckets. Former, existing, or even prospective participants in the financial institution. Second, employees, of course, that's quite understood. But employees could mean anyone from a front office person, a middle office person, and technically even a person, the coffee lady is technically could be an employee. And service providers, and this is where it gets a little bit controversial because service providers could be very broad, right? It could include an audit firm, it could include a law firm, it could include a compliance consultancy like us. Technically, it could include even IT or anybody providing outsourced services, or not just outsourced services, but also any service providers. So that's the proposal for the Omnibus Act. The proposal is to widen the scope of persons who can receive a PO. I'm going to turn to one of my fellow panel members, Chai Kit. Your thoughts on this?
Hi, sure. Thanks, Nizam, for the very clear articulations of the backdrop of all that stuff. Now, I think in general, the ability for the regulator to equip itself with the necessary power, such as the ability to issue POs as one form of consequence management if someone fails his duties or responsibilities, is certainly a necessary thing to have. Now, I personally have issues with this very broad definition, which includes, you know, the few points that you have mentioned, because ultimately, I think the FI itself, you know, whichever legislation you're legislator under, have to remain accountable and responsible for what goes on within the organization, right? Whether is it someone missell a product, or someone who have failed to identify a risk area properly, and therefore resulting in the organization breaching, say for example, the AML legislation and whatsoever, right? So the expansion beyond to any person, you know, including service providers, including prospective participants, I think that will be a little bit too excessive. And it's always good to have excessive power so that MAS can be so-called trusted to do the right thing, and then they can pull the trigger whichever way they want. But I don't think that is necessary. That is what I would say. But I would add one more point here on POs particularly, because I see PO as a form of penalty, which means that it's a form of consequence management if something goes wrong. So in order for the regulator to be equipped with this wide-ranging powers, I think we need to be very clear on a few things first. Who are the people that should be targeted? Because I think that maybe that will be one of the later questions. But I think if you can look at the other consultation paper that was issued in 2018, which is called the Individual Accountability and Conduct Guidelines that they issued in 2018, was concluded in 2019, I believe, but there wasn't any further updates as to the implementation of that. Now, for those people who remember, and you can Google this quite quickly, if you are able to find that, they actually specify very, very specific roles, head of IT, head of compliance, head of finance, head of operations, and head of risk, and so on and so forth, as key core management function that they need to remain individually accountable and have right conduct, and fit and proper is one of the criteria. So I would suggest, you know, to this committee or to this group that MAS should link the two together, because you can't just say that I want to have vast power to hit anybody I want, but I haven't really concluded on the types of person and the roles of the specific person that I think needs to be contained within the core management of any FIs in question. You know what I'm trying to say? So linking the two will be a good way in order to make sense, and downscoping it to employees and people within the core management function will achieve better outcome for the regulation, as opposed to just say that I want to have very wide-ranging powers under POs proposed.
Yeah, I suppose you can argue that the more detached a person is from management or from a front office role, the less probable he can cause harm to an FI.
Management these days goes beyond front office, which is why under the individual accountability and conduct, which is a good regime to actually come out with, because that falls under the senior management regimes in other jurisdictions as well. So if you have that, you know, you have head of IT who is not a front office person, and even if you look at the subsequent question, jumping the gun a little bit, because it's kind of relevant to talk about the two together, because you can't have risk management and control function in a broad sense. You know, within that risk management and control function, and MAS defines this in the consult paper itself, there are probably about 11 pertinent risk categories, you know, and it could well be done by 11 different people in an organization or teams. So it's actually very, very broad.
Thank you, Chaikit. Any of the other panel members, if you want to jump in, please do. Okay, if not, maybe we can go to the next poll question. Kevin?
No, I would like to add, the broader the scope, operationally, it will cause problems. You know, as financial institutions, the FI has the onus to make sure that whoever they hire for regulated roles currently are not subject to any banning orders. So I don't think we have any details on how this proposal will be operationalized, how whether there will be a published list of all the POs. In the past, this list of people under a banning order or PO is only made known to the financial institutions, and it's already quite a big task for the FIs to track that the regulated reps that they hire are not subject to any PO. Now, if you want to broaden it to employee service providers, I imagine there should be some kind of like public lists of people who are subject to such banning orders. And then the onus is really on the FI, that whoever you deal with as your employee, whoever you hire, all these people need to be checked thoroughly. And yeah, so it will create some kind of operational, and I don't see the details being covered in the consult paper.
That's a very good point, right, Mason, you brought up, because I think increasingly, if for people who've been following, you know, the regulatory actions MAS have announced from time to time, there have been POs that they put on the public domain, and I'm pretty sure there are POs that they don't put on the public domain. So there's a ability to do that. But bearing in mind that in this proposed Omnibus Act, MAS was actually quite clear to say that, you know, it will affect livelihood, and I think the intention is to be on a risk proportionate manner. And again, you're right that I don't think they actually state out, and currently they also are not very clear under what circumstance they publish a PO and what circumstance they don't. You know, so worse still, if it goes to employees, whether it's in Singapore or elsewhere, or prospective employees, or, you know, service providers, then the reach is huge. It's needle in the haystack exercise.
Yeah, I mean, if I may just add my perspective on this, is not only is the breadth and the depth of it is expanded, which I think there could be some very good reason, but in order to do so, they need to be very clear in terms of the standards and the type of conduct that could potentially fall foul of this type of prohibition orders. I think that's where I think we should request from MAS to provide greater and better clarity before this is implemented, because of its wide-ranging implications.
Exactly, which is why I suggested earlier about for people to look at the individual accountability and conduct guideline that they proposed 2 years ago, because in it clearly specifies roles that are caught under that guideline or the proposed guideline, such as the head of departments, whether front or back office, doesn't really matter. And that is a clearer and more manageable and more contained approach, rather than to say risk function, risk management and control function. Anybody who takes risk, like.
Okay, you're jumping the gun here, check it. Let's get to that in a bit. But I really want to get to the poll question. Kevin, can you flash the next poll question? Okay. So the poll question number 2 is, what do you think the scope of the PO should be? Following on from what we just discussed, should it just be FIs and their employees, or should it include service providers as well? I'm sorry, we can't include all permutations here, but between the two, choose one. All right, so people are voting. We should be in the mood for voting, having just gone through a general elections. So the returning officer, Mr. Kevin Pang, can you please announce the results?
The good thing is that people don't have to queue in the sun.
Yep, just 10 more seconds and we get to close it.
It'll be interesting to see the results.
Okay, here we are. Pleased to announce that the scope of the PO should be the FIs and employees. So I think that's the, I mean, it's pretty tight, right? I mean, it's like almost 50.
Can you flash?
Sorry.
The results.
Okay. Yeah, it's pretty, I will want to announce that it's pretty tight. I think it's like almost half-half in terms of the opinions.
Okay, slightly more people think that it should just be FIS. But yeah, I mean, it's quite a close view.
Actually, sorry if I could just jump in on this interesting result, because I would have expected the right thing being having more, you know, but for people in the audience, which you are probably comprising FIs yourself, And the inclusion of service provider into this proposal would perhaps, I don't know, I'm just guessing, right? That there is perhaps a mentality to say that if I engage a service provider and then, he or she, they fail in their discharging their responsibility, yeah, sure, service providers should be made responsible for it. I guess that's why people voted in that sense. But the long and short of it is that regardless how you utilize a service provider, and this is not me disclaiming responsibility, FIs themselves have the accountability and responsibility stays with you. All you use a service provider for is basically to discharge certain tasks or certain duties, but it doesn't change the fact that you remain responsible for engaging that service provider, and MAS will probably not get involved in issuing a PO to a service provider. That's my sense, because it gets quite complicated.
I think it's worth asking for clarity in what kind of circumstances the MES envisage.
Yes.
Issuing a PO to a service provider. Because
exactly.
There could be a very wide spectrum, right? So, for instance, if I provide courier service to an FI, and one of my courier guys get charged for, let's say, a violent crime, he causes grievous hurt. I mean, that's got nothing to do with FI, but does it go? Is it a PO-able offense? I don't know. So we need those kind of clarity. That's probably an extreme scenario.
Yeah. I mean, to be quite frank, if I could just add on one point here, I mean, a more relevant example would be, say, for example, right, if people, from an AML point of view, if people are using a certain database, right, to check for PEP sanctioned adverse media, whatever, I'm not naming any names, but a reputable one, for example. Now, and if that database has been checked and therefore it's not doesn't come out with that hit, for example, for whatever reason, they could have their own definition, let's just take it as it's in good faith, then how is that, the PO is how is that going to be issued to an international company that operates in the US or in the UK and only have a little sales office in Singapore with a few salespeople? Are you going to PO the salesperson selling that product to the bank or the FI, or are you going to PO the company head office in US?
Okay.
I thought I'd jump in here because it may not be clear. The PO is only meant for individuals.
Sure. Or you go to a director of the, or you go to the director of that organization and hit all the way to the top. I mean, where do you stop? That's the point. No point hitting the sales guy in Singapore, because that's probably the easiest target you're going to end up with. And if you have the concept of expanding to service provider, then the risk on the service provider operating and having business in Singapore versus those people having one or two sales rep in Singapore, the outcome is completely different.
Okay, yeah, Robin, do you want to jump in?
Yeah, I was just going to say that from what I see on the broad technology front, from a technology perspective, this is, the more recent developments is focusing on empowering compliance and AML departments to make their own stuff up. For example, on the Napier side, we, rather than have like rule changes, being dependent on the vendor, i.e. us, we have a drag and drop function where compliance officers, AML officers can create their own rule set. And so we call it empowering, but in a way, it's really down to the policy that the FI instills to develop whatever those rules are. So I think the trend is kind of heading that way anyway, and whereby it really is going to be less on the service provider versus the FI. Sorry, my 2 cents there.
Thanks for that. I really want to move on because I think we just done with question 1. So let's move on to the other issues. Okay, here is another issue relating to POs, right? And this is the grounds for issuing of POs. Now, if you look at the genesis of the PO regime under the Securities and Futures Act, typically the sense I get is, being one of the drafters of the Act previously, was that this was meant for more egregious cases. So just if you look at 101 of the SFA, for instance, These are circumstances where the MES suspends or revoke the CMS license, or if it's a case where there's been any prohibition or contravention of the act, or a person convicted for an offense involving fraud or dishonesty or civil penalty. So you get a sense that it's meant for really egregious cases. But now what the MES is proposing is that they want to peg it on the fit and proper guidelines, which is FSG G01. If you are an FI, you should know this. And you would also know that this is a very broad set of guidelines, because while there are three main themes of honesty, integrity, or reputation, there are the issues of competence or capability or financial soundness, but there are many very loose areas where you could be deemed to be not a fit and proper person, or there is a fit and proper issue, not necessarily barring you from applying for a license, but requiring you to declare that and to explain to the MES what the issue is or whether that's been resolved. So again, the FSG guidelines is meant to be very broad, because the policy approach seems to be to want you to declare those, and if that can be explained away, you should explain away to the MES. But now this is going to be used as a basis for the issuance of POs. So that's quite, in my view, a shift from the original intent of the POs. Of course, the MES gives the assurance that it will carry out a holistic and balanced assessment of factors such as the nature and severity of the misconduct, how relevant it is to the financial sector, and the passage of time, whether it's something that happened 6 months ago as opposed to 20 years ago. So the question posed by the MES is, to ask for comments of applying the fit and proper guidelines as the basis for the issuing of POs. So I'm going to turn to Meishan, your thoughts on this. Meishan, where are you? Did she just drop off?
Okay. Sorry.
Okay, there you are. You're in mute. Okay.
No, so actually I don't see it as much of a biggie. All along, MAS has worked off the fit and proper guidelines, and it's principles based. So I think it's actually fine. The problem with the previous versions was that it was very much cut and dried. And at the end of the day, MAS will still take a holistic and balanced approach when assessing POs. And the guiding principles have always been the fit and proper guidelines. So I don't really see much of an issue with that. It does make it more difficult for the MAS, to be honest, because it is principles based and not so easy for someone to opine on honesty, integrity. All these are qualitative assessments, but it's something that the MAS would have done anyway. So I don't really see that as, introducing anything new in that sense. This one is probably an okay change.
Okay, any other thoughts from any of the panel members?
I think, sorry, if you look at the question itself, the MES is asking, I don't know whether this is just semantic, but I think they are specifically asking comments on the proposed law to apply fit and proper test as the sole ground for issuing a PO. I think that word is sole ground, and I don't think it should be the sole ground. Because it's a little bit contradictory when you say, okay, should I do it on a sole ground basis, but yet I want to be risk proportionate, and then I want to consider various things. Then that's not sole ground. I think the question that they were asking is sole ground.
Sole ground, it's fine as long as you feel that the fit and proper guidelines, which we have been applying all along in the financial services industry, at least for regulated reps, is principles based and broad enough to capture the areas which are important.
But it's principle based, but I see sole ground as being too blanket.
Okay.
I think if I may add something here himself, in terms potentially it could be an issue. Obviously, with this kind of principle-based guideline, the expectation is on the incumbent, be it if you are one of the key stakeholders in the FI, to basically disclose, obviously incidences that may happen within your organization, within yourself, or even associated companies. Assuming if you have an affiliate branch, that something happens to them. are you then obliged under this to basically disclose? I mean, in terms of materiality as well. So, you're going to end up, I mean, obviously you're going to be on the side of caution, and you're going to start disclosing everything that you you think. And again, this is where I think it can potentially be quite onerous on the key employees in the FI.
I think the mission, I think I have a different take on this, but I like the diversity of views, is that, when you issue a PO, it has a very severe impact on the livelihood of a person, because you're blocked from, taking part in the financial services sector. So it's actually quite drastic. And to me, when you want to have that kind of an impact, the threshold should be a bit higher rather than fit and proper threshold.
Well, which is why I say it shouldn't be the sole ground. But I think they are saying, it's a very theoretical debate here. They are saying that if you are barred, given a PO for, say, for example, finance function, okay, you theoretically can actually take up another role in the operations department, because they're not the same. But the reality is that if you have issue a PO, I don't really think any FI would actually care about whether is it this function or that function. If you receive a PO, you receive a PO, full stop.
Okay, so I think that brings us to the next poll question. Kevin, can you kindly put it up?
Yep. Give me a moment. I'll just set it up. The next one is coming. Okay.
This is actually to get a sensing from the audience as to whether you think the PO should be issued for fit and proper breaches, which is an MES proposal now, or should it be for more serious breaches? So let's pull away.
Oh, and sorry, whilst waiting for the poll, I think just for the response back to the MES on this point, I think we should ask, if not already thought about, how should it be, like what Asman is asking, should it be a voluntary disclosure on a periodic basis, like misconduct reporting, like what FI is going through right now, on a quarterly basis? Or is it, whenever someone discovers that there is non-fit and proper within the organization, and then we have to voluntarily report back to the MAS within X number of days for them to consider a need or not a need for a PO? Or would it be wait till they come in for inspection and it is, oh, how come I look at your disciplinary action and then this wasn't reported to me?
Okay, the poll is finished. So the thing is that it's quite overwhelming. I think it's everyone believes that it should be more for egregious breaches rather than for a breach of fit and proper.
So this is stronger rather than the Jurong GRC result. But yeah, Chakit point is interesting, and I think Asman's points earlier on reporting, right? Because currently, I think for the misconduct reporting, it tends to focus on regulated persons, the RATs, and under the SFA and FA. I don't think there's a regime under the Banking Act. I doubt there's a regime under the PSA. I might be wrong. But clearly, when you have this, then the question is whether there's a similar obligation to report. But again, my gut instinct is I'm not sure whether we want to ask for this, because I've learned that you're careful what you ask for. Sometimes you get it.
Okay, you figure out what is necessary, because at the end of the day, if it's not clear, then I don't think people benefit at all. But because if they are trying to create this Omnibus Act where they lump all sorts of general obligations into one legislation, then the outcome of it is that it is the people being regulated that needs to suffer for a poorly worded regulation or the unintended consequence of a legislation that is being put together.
Yeah, I think I agree with Chaikit points and really second that we definitely need to frame some of these responses, at least from the industry. Given the extent and breadth of this, we need to be very clear to MAS that they need to, first of all, provide more exacting standards. And then when does the duty to disclose arises, and all of this kind of to get clarity around this issue, because
especially
wide-ranging impact.
Especially for the people who are new to the PSA regime. I mean, apart from those people who are in the SFA for years, it's clear you've been doing misconduct reporting on a quarterly basis for the longest time, and no problem with that. But for people who are new to this, and then you can't have a misconduct that doesn't get considered for PO, it's not mutually exclusive. That's what I'm trying to say.
Yeah.
Okay, let's move on, guys, because I think
Of course, we should
manage the time.
Yeah.
Okay, and this is a point that I think Chaikit touched upon earlier as well. What is the effect of a PO? So currently under the current SFA, FAA, and IA PO regime, if you are PO, you can be barred from holding certain posts as directors, substantial shareholding, or management, or conducting regulated activities under this legislation. The proposal now is to widen this. So now there is a wider impact if you are PO'd. You could be barred from, say, handling of funds or safeguarding and administration of digital payment tokens. So it's interesting that DPTs are being singled out here. And then risk-taking, risk management and control, or critical system administration. So they've even gone to middle office and back office roles. So Chaikit, your comments on this widening of the impact of the POs?
I've said earlier, I think that they need to scope this down because as it is proposed, it is too broad, and which is why I point the group back to the individual accountability, because that PO estimation has said it points to an individual, not a corporate. Whereas the function points to a team of people and also is a construct of the availability of resources within the organization, right? So you need to pinpoint the head of risk or the chief risk officer or the head of finance or whatever, right? CFO, in order to be able to say, okay, these are very clear expectation. Then if you don't fulfill these rules in the manner which the guideline have prescribed or proposed, then the ultimatum is that you may be issued a PO. I think that's more manageable for everyone, rather than say risk management and control function. As I said, that if you look at the definition of risk-taking function, MAS defines, it includes about 11 different risk categories.
So you're suggesting that it should also be packed on the seniority or the
yes, I'm saying that because they have, I didn't create this. MAS created individual accountability and conduct guideline 2 years ago. And they should close that properly and link that back to this proposal here, because it's the same thing we're talking about. Okay. It's either you call it a function or you call it a head of a function. What's the difference? And if a PO has the effect on the individual, then you tell the people who are responsible for it within the organization.
Okay, thank you. Any other thoughts from any of the panel members? How about the ability of MAS to prescribe additional activities? So they could widen this. So the proposal, the MAS wants to have the power to widen this, whole proposal to widen the scope in regulations. So they don't have to go to Parliament. They can, issue it by themselves. Any thoughts on that?
Well, okay. I believe this is already wide enough that they don't need to extend it.
It's actually too wide for what.
Yeah, it's already too wide. Yeah, so it's already defined the kind of activities, and I think within this kind of activities, they should really further define what is expected. And I agree with Chaikit's point. They maybe need to tie it with the previous regulation that they've issued to provide more certainty and clarity. Okay,
thank you for that. Yeah. All right, I'll move on now, and we're moving to a different area right now. Forget this slide. Is on the whole issue of VASPs. VASPs, as I mentioned, are virtual asset service providers, and this is quite core, and I think this is one of the key reasons for the Omnibus Act. Being a member of FATF, so MAS has to comply with FATF recommendations. And if you remember the FATF VASP standards, it's actually couched very broadly to include even persons who are conducting activities where the clients are outside of that territory. So the focus now is on VASPs who might be created in Singapore. So you could be a Singapore company, private limited, or an LLP, or even an individual person with a permanent residence in Singapore, but say conducting VASP activities outside of Singapore. So they could, for instance, be running OTC crypto trading service, but only onboarding non-Singapore resident customers. So they will be caught under this regime, or they could be an exchange not onboarding Singapore residents. So now they will be caught under this regime. So remember that if you already have got Singapore resident clients, you should be licensed, or you should have an exemption notification or exemption approval from the MES under the PSA. So this is now a new regime that is meant, I think, so apart from the FATF criteria, I think that there's also a reputational risk issue, where if there's lots of Singapore-based companies which think that they don't need to be licensed, and then they target non-Singapore residents, and there are some issues, therefore there could be a gap. And the other issue that's quite front and center is, of course, AML and CFT, because there is a perception that cryptos have got higher AML CFT risks. So it's really that reason that this is being introduced. So any comments on this? Azman, I'm going to turn to you. From a crypto exchange perspective, what are your thoughts?
Okay, thanks, Nizam. Okay, I believe, it's clear when FATF came out with the legislation last year in 2019 that they expect a lot of the member countries to abide by this, and it's clear with this Omnibus Act, MES is trying to obviously fit in some of those activities that are not currently covered under the SFA and under the PSA. And therefore, I think it's important for us to understand what those activities are that fall outside of the current SFA and PSA regime. In terms of those 5 key regulated activities that MAS has prescribed to comply to be in line with the FATF standards, I think those are fairly clear in terms of what they expect. So you do not need to be in possession of those tokens as long as you facilitate those type of services that covers those tokens, then potentially you are in scope. I think the bigger issue here is to see is in terms of to get further clarity from MAS is in the definition of what they think digital tokens can mean. And this, I think, in line with what FATF considers as virtual assets. In the current definition, I think it's clear that they obviously want target digital tokens to cover DPTs that's already covered under the PSA, and the tokens that are characterized under the SFA and that can be transferred digitally. So now they have a third definition that I think is potentially could be problematic, because they potentially could open up a backdoor to all other types of tokens that are not covered under this. And the reason why I'm raising this point right now is because if you look at the definition of the PSA currently as it stands, there could be tokens that are considered purely to be utility tokens and not covered under the PSA, meaning they do not satisfy the means of exchange by a section of a public test. So therefore, they are considered unregulated token under the PSA. And currently, so they are not regulated under the SFA and under the PSA. So now the next question is, do they satisfy this Omnibus Act to be considered a digital token? Under that third limb, potentially MAS can, shoe in some of this backdoor approach. So I think we need to get some clarity on that. So that's, I think, the first instance we as a body needs to obviously provide feedback to MAS to get greater clarity as to what they considered the third limb of that definition of digital token. Okay. Now, I
think, Azman, I think we're moving ahead of that. But okay, just to on Azman's point, since he mentioned it, so the MAS has introduced a new concept of a digital token. So in the past, there's the DPT, digital payment tokens, but now DTs are meant to cover DPTs under the PSA. Second limb is digital representation of capital markets products. So securities tokens, like those traded on iStocks, are also caught under digital tokens. And Azman mentioned a third limb. I didn't summarize it here, but there is also the possibility of further prescription by the MES. So that's just to cover off on that point. Sorry, any other thoughts by the panel members on this point? Sorry, I cut you off, Azman.
No worries.
Can I just add that perhaps we got to put it in a nicer way to MAS, depending on how you want to draft it.
Be always nice to MAS.
Yeah, we have to, right? No. The thing is this, right? Whilst FATF have come out with the definition of VA and BAST, a while back, and there's only one term, virtual asset, right? And or used synonymously, as we all know, cryptocurrency in general. But MAS, in its vast amount of wisdom, they have split it into digital token, securities token, and then now under this new Omnibus Act. So the outcome of this is that cryptocurrency in general is now covered under 3 different sets of legislation, right? PSA, SFA, and new Omnibus Act. That doesn't sound like a very expedient way going forward. Would not a better outcome be that I'm not sure whether they've done that, but they should have considered amending existing PSA as well as SFA, which they have done over the number of years, rather than to introduce a new legislation and slot in this so-called element here, and then say that, okay, this satisfies FATF and it's meant to close the loop somewhat for something that they couldn't fit into the existing legislation.
Yeah, thanks for that. Let's just jump to the poll right now, Kevin, poll master.
Okay.
Poll number 4, just to get a sensing from the audience. Okay, so it's back to the fundamental question whether you agree that VASPs providing services outside of Singapore should be regulated in Singapore. So it's either yes or no. So remember, these are companies in Singapore providing services to non-Singaporean residents. So whether they should be regulated or not. So let's vote away.
Coming up fast and fury. So I think we should be able to meet 100% pretty soon.
I've always wondered why they use the term returning officer.
They're returning some of the people to power. I think that's probably the term, but no longer really relevant. So.
All right, Kevin, let's share the results.
Okay, just 5 more seconds to a minute. 3, 2, 1. Okay, I think overwhelming. Well, won't exactly overwhelming.
Can you share the results? I don't.
Yeah, sorry. Okay, so not exactly overwhelming, but I think a strong majority that says yes.
Okay. So yeah, people seem to be in alignment with that. Okay, let's move on. Okay, so we're still on the issue of VASPs providing services to outside of Singapore. And okay, this is again another area that's interesting. Now the MAS is defining the scope of services. Now you remember that under the PSA, under the current iteration anyway, the MAS regulates either an exchange, like Upbit, where you have multiple buys, multiple sells, and there's an order engine that matches buys and sells, so you're an exchange, or dealing. Dealing could be like an OTC platform where I sell you BTCs and you buy BTCs from me. However, under the concept of DT services, this is going to be a broader definition compared to the PSA because it includes things like facilitating the exchange of digital tokens, right? So that's a new concept. Inducing or attempting to induce someone to buy or sell digital tokens. Accepting digital tokens for transferring or transmitting digital tokens. So if I move it from wallet to wallet, I provide that service. That is also an activity. And safeguarding and administering digital tokens. So if I provide custodial services for digital tokens, I am now specifically caught under this Omnibus Act. And advisory service on digital token. So if I provide a service that, okay, maybe now's a good time to buy BTC rather than XRP, that is a regulated activity. Even if these are not regulated under the PSA, and there is no need for the DT service provider to have possession of DT. So for instance, if in an advisory relationship, you might not send any cryptos to me, I just provide advice, I'm still caught. So this is actually wider than the PSA definition. So it's a bit of an anomaly. So
I think if I may, I think, sorry
Azman, I was about to reach to you.
interject here, Nizam. I mean, in terms of, I think that's why it's so critical and important for us to get full clarity of what's this defined terms of DT supposed to be. I mean, clearly what the proposed definitions only suggest that it could be under the SFA or the PSA. Now, the next question, if they are not under those two, clearly they are unregulated today. Are they then still considered to be fall under this Omnibus Act and therefore needs to be licensed? So for instance, a utility token, if indeed it can be considered a DT, then anyone who's dealing with utility tokens would need to be licensed, which I think it would be a problematic situation given the scope of the kind of services that is expected to do.
Sure.
So I think it falls back into the definition. I think it's important that we have clarity on that.
Yeah, but any thoughts on the fact that your Omnibus Act's definition of DT services is a lot broader than the DPT services definition under the PSA?
Because the fact that it's supposed to cover DPT, I think MAS is doing is extending the scope of activities to cover, for instance, like it says here, safeguarding or advisory services. So in that scenario, what I would imagine is for all DPT issuers or arranging or custody of DPT would need to be licensed under this act.
I'm not so sure about that. I'm not so sure about that, Azman, because the premise is that this applies to Singapore companies targeting wholly non-Singapore resident clients. So if you are Singapore, let's say your exchange wants to provide custodial services for DPTs, which are DTs, I'm not sure whether you can even apply for a license. So that's
in
the
that
point
case,
that
then there would be, I see, okay, then
there's a
clearly
mismatch,
there would be a mismatch of the two services. It should be aligned to the PS Act rather than overstepping it. Then we have a problem here.
I think the reason why it's here is because the FATF definition of VASPs is actually very broad. It includes all these activities like providing custodial wallets and advisory services or brokering services. So therein lies the dilemma for the MAS, that they have to be seen to be, abiding by the FATF recommendation. But now the net effect is that this is a wider net compared to the PSA.
Yes.
So that
correct. Which is why when they came out with PSA, it's activity focused, right? It's activity driven. They have like 7, 8 activities, regulated activities. It's the same thing as SFA that they've done quite a number of years ago, right? And it's all activity driven. So the reason why they moved off to an activity focused regulatory framework is obviously to allow them the flexibility to add certain regulated activities along the way as they see that the market has evolved. So in this circumstance, which is to the point that I made earlier, if you imagine that these combinations of some of these activities, why can't it be scoped into additional activity? Because you mentioned the point about wholly targeting outside of Singapore clientele, which means that you can, and I'm not a lawyer, so again, there was obviously legal things to jump through, right? But if you can specify that right now PSA and FSA are covering businesses that are targeting Singapore people as one limb of it, then the excluded activities will be, okay, you are here, but you're targeting outside. So then why can't you just in-scope the regulated activity for these two legislation to say that in Singapore or elsewhere? And
I think this extended,
extra...
this extended scope of DT services should be better dealt with under the PSA. That's my view, because that's where the regulated activities has been mentioned in terms of dealing and facilitating.
Exactly.
And it's simple enough for them to include the other 3 or 4 activities within that space, rather than providing it inside and creating now this mismatch.
And if it is a securities token, that is under SFA for now, then you can see that these scope dealing and the definitions seems very similar to dealing in securities.
Yeah. Actually, on this point, we've got some a comment from Bibiana Tay. Her thoughts are that if the VASPs are not offering to Singapore residents and they're currently not regulated, are there restrictions for them to transfer the tokens to a Singapore wallet? I guess there are no restrictions, so I agree with you, there are no restrictions. She agrees that these activities should be regulated under the PSA. So for the rest of you, if you have any questions, there's a Q&A function as well. So you can put it in the Q&A or if you like the comment section.
And I would like to ask, perhaps it's also something to ask back to MAS, and maybe Nizam and you guys will already know this. Now, whilst SFA has got extra territoriality reach, which is under section 339, do you know if PSA itself has got that provision?
No.
It doesn't, right?
No.
And okay, that's number one. And under this new Omnibus Act, is there anything said about extraterritoriality reached?
Well, by definition, it is extraterritorial because you are targeting, institutions.
No, I get that, but
Singapore.
Is there an effect of that? Because your activity is carried out in Singapore, but you're facing clients that is not within Singapore. So it's a little bit strange that legislation is issued in that sense.
Yeah, there is an inconsistency because, actually one would have thought that the SFA approach is quite broad because it also includes instances where an act happens partly within Singapore and partly outside Singapore.
Yep.
And the argument is that if you are a Singapore company, even if you target non-Singapore residents, the transaction is partly here and partly there because there is a service provider here.
Correct.
But they're taking a different approach for this act. So there's a bit of a policy inconsistency in my view.
Correct.
Malaysian might have a different view, I think.
So the question would be to ask them, why don't they have some consistency across relevant?
Correct. I think the fundamental question, as Chaikid and Asman pointed out, is why not, and BBNA as well, why not have it under the PSA? So therefore you can have a consistency of approach. Otherwise, this scope of activities under the Omnibus Act is a lot wider, and the PSA definition is a lot narrow between activities, right? So there's a bit of an inconsistency.
No, I think it boils down to the licensing and the conduct requirements that I assume you'll share later on. And this one is in a way a slightly lighter touch compared to what's in the PSA. So I suppose what the MAS is trying, and I could be guessing, what the MAS is trying to do with introducing this particular scope of DT services that's just wholly outside Singapore is to bring in a lighter touch kind of regulatory regime for entities that are based in Singapore but solely serve overseas.
Mission, I think it seems to me, looking at the requirements, it's fairly similar to the requirements for those dealing in DPTs under the PSA.
Okay, let's get to that in a bit.
Yeah, but if you notice under the SFA, it is very much light touch, just needing one person. So
correct,
I
under
think
the PSA.
is to avoid any complications from the SFA point of view.
You mean the PSA?
SFA.
All right.
So for securities token is very much light touch.
But why create too many variants of this and potentially it could lead to regulatory arbitrage?
So actually it was created with PSA, right?
Yes.
Right? Different act just for DPT.
Yeah, actually it's quite different. So for instance, one example would be the travel rule. So technically RMOs, do they have to abide by travel rule? I don't think it is in the SFA 04 and 04, right? But it is in PSN 02. So there could be those sort of policy inconsistencies, I think.
So for securities token exchange such as iStocks, we abide with the full AML notice in the traditional sense, and it goes way beyond the travel rule.
Okay, but I mean, strictly speaking, from a regulatory, you are being good citizens, and that's great. But strictly speaking, I think the travel rule is only in PSNO2, unless I'm, if I'm,
yes,
I think that is the position. But I think the point is, again, ideally, in an ideal world, you should have a financial services bill that, you know, have similar rules for similar products. But now the difficulty is you have the SFA for securities tokens, and then the PSA for DPTs, and now, finally, the Omnibus Act for DTs, and which with a broader set of activities. So it's very disjointed in my view. As if that was not enough, the MES actually asked, do you know of any other activities that they should be regulating? Any others or not? Any other advisory services?
You should just say no.
Fund management? I don't know, but if any of you knows, please let us know, either in the chat or you can drop us an email.
But I think the point that you raised earlier on, Chaikit, about, you know, payment tokens potentially being a fund management activities, because that's not covered under, obviously, under PSA. So, you know, if you want to be good citizens and inform on MES about this, potentially that could be one area.
Okay.
Oh no, I'm not gonna snitch on people.
All right, Mr. Returning Officer / Poll Master, the next poll question, please.
Okay, coming up.
And
that's number 5, and there we go.
Okay, what should be the scope of DT service providers? Should there be an alignment with the PSA? That's the first option. Or it should be the second option, which is wider than the PSA. Sorry, it should be it's a typo there. Yep. So vote away.
Quite interesting to see. Sometimes some of this poll actually form a majority opinion at the onset.
Can I just say it's probably not up to us because MES has made it clear that one of the reasons why they're introducing this scope of activities is to meet FATF, right? And Chaikit, yeah, the expert, these activities are exactly those that FATF wants to be covered. So I don't think there's much wiggle room.
No, which is why I'm saying that, you know, rather than introducing a new legislation just to satisfy FATF, because this is not about satisfying FATF, right? Because once you introduce a law, you will need to maintain it, and you will need to maintain it. People need to comply with it, you know. Versus there's on cost that follows with it. That is the burdening of the whole, you know, industry, and I'm not sure how many of such businesses actually exist in Singapore that provides such services to overseas people that you cannot in-scope it into the existing PSA/SFA and expand the coverage there.
Yeah. Okay.
That's all I'm saying.
So the returning officer has actually published the results.
Overwhelming.
So, overwhelming agrees it should be a similar treatment as the PSA. So this exceeds the Jurong GRC test.
but you know you can skew a result of a poll by the way you ask questions, yeah?
Of course.
Yes.
It's called gerrymandering, right? Okay, that's why we have electoral commissions. Okay, next one. I think Azman sort of mentioned this when we were having a chat. Azman has got this knack of, you know, rushing through the issues before we discuss it. They're just taking a dig at you, Azman.
It's okay.
But here are the requirements. So there's some, you know, upon admission, some requirements like you must have one executive director resident in Singapore, similar to the PSA. Obviously, you must be incorporated in Singapore. So there are some actually financial requirements set by MES. So there's actually capital requirements. And the directors and CEO must be fit and proper persons. Ongoing requirements, permanent place of business here. There should be one person to either address money laundering, AML, CFT issues or complaints. You must keep books. I suppose electronically is also fine. You must continually meet your financial requirements, your capital requirements, fit and proper issues. Any thoughts on this? Seems to be broadly similar. And then I'm also jumping the gun, but there is also a requirement for AML. As I mentioned before, MES views AML for CFTs to be front and center. So there's going to be a plan to introduce a new FSM notice specifically for the Omnibus Act, but as things stands right now, they will apply the PSNO2, which is the notice for DPT players here in Singapore. So in other words, there'll be no low risk exemptions. For instance, even small amounts, even if I have a Bitcoin ATM that sells $1 worth of Bitcoin, I must do KYC on that person. So that is the approach. So maybe I'll fold these two into one. Any thoughts on this? Azman, do you want to kick off?
Sorry, what was the question, Nizam?
The question is, what are your thoughts on these ongoing licensing requirements?
Well, I think it's looking at it purely from the PSA, and I think in terms of the conclusion that we come to, that the overwhelming majority thinks that it's better to be discussed. And, you know, clearly to me, it suggests that it's in line already in terms of the requirement for licensings and the criterion that they're setting. So why not then push a lot of these other regulated activities, the other 3 or 4, meaning facilitating, advisory, to be part of the PSA and expanding the PSA to cover those type of regulated activities, so that we have rather than creating these other issues about what goes into the definition of digital tokens, creating a lot more uncertainty. So I think this is another, I suppose, a plus point why I think MAS should, in that perspective, cover this whole segment under the PSA and expanding it further to cover these areas as well.
Yeah, because I think back to the point,
thoughts.
I think there was a debate as to, I think Mason brought up the point as to whether the ongoing requirements for these new VASPs trading in DTs are going to be different from the PSA. So I think broadly they're similar. I'm not sure what the financial requirements are, because there are all these requirements here.
I think it's about 250, if I'm not mistaken, off the top of my head.
And then you also have got AML, which is quite a big chunk of compliance for PSNO2 also has got a travel rule and all the fun things that apply to crypto exchanges. I think TRM may not be in scope, but that seems to be the only thing that's not applicable for these new creatures. Any thoughts on this? Any other thoughts from any of the panel members on the PSNO2 AML application?
Yeah, one thing I want to add is, I mean, just looking from a law enforcement perspective, we're seeing a lot of activity, like particular, well, actually both terrorist and money laundering activity happen within ASEAN itself. Like a lot of the stuff is getting funded out of our region specifically. So I don't know. This is where, I mean, going back to the technology side, I think any company that has a good I think it's important that you, when you're going to the data providers of both sorts, right? Not just like your screening, but also your blockchain monitoring companies, that they have good underlying data that has good ASEAN coverage specifically. So for example, I know the Merkle Science guys have an intense data set focus on the Philippines, for example. So if they're there, like just marking Filipino wallets specifically. They mentioned to me they did like a 3-month project on that country, that jurisdiction in particular. So yeah, I think that's from a practical element. It's important to ensure that you have a good data provider that covers this region right now, because that's where law enforcement's eyes will be. And then just on a general term, I mean, some other things that that we've seen from our customer base that guys aren't as focused on, which I think would probably come to light is or come to fruition rather, is enhanced due diligence checks. So doing that deeper dive rather than just a straight screen and then moving on. Ultimate beneficial ownership checks as well. I don't see as prevalent, and I know MAS is pushing it really hard, but artificial intelligence as well. But there's different types of approaches that you could take with that. You can take it from the AML officer's perspective, where you minimize the amount of work needed done by the AML officer, versus the fraud approach, where you're sticking the algo around the customer perspective as well, just to spot anything out of the ordinary. But these are things that I see coming later down the line from a reg tech perspective that the industry should keep their eyes open for.
Yeah.
By the way, regulators and law enforcement are already using a lot of this stuff already. So yeah.
Sorry, Niz, I'm just coming back to the actual consult question itself on, you're asking about the ongoing requirements. I might have missed it. Did they prescribe exactly the financial requirements for this proposed Omnibus Act yet? Or if you go back one slide from what you are showing now, it only says financial requirements. They didn't really specify, is it 250 or is it 150 or anything, right?
I didn't see it. I think.
Yeah. So perhaps
the 250 is in the PSA, I think.
No, PSA
No,
is fine because that's already existing. I'm talking about if this were to be set in motion and they're gonna go ahead regardless what everybody says, then I think at the minimum they should make the financial requirements consistent with what is already in PSA, so that there is a level playing field. I think that's important to stress.
Yeah, we can make that point. All right, I'm going to move on to the last segment. Sorry, but before that, yeah, the MAS gives assurance that there will be transitional arrangements to exempt. If you are a DT service provider caught now, you will be given time to apply for the license. And then, okay, the other point is quite interesting as well, that remember these $1,500 threshold for the travel rule, right? The cross-border transfers. The MAS is now saying that whether it's $1,500 or if they change it going forward, the value will be set in the new Omnibus Act. So even for DPT service providers, let's say Azman, for your exchange and you have a travel rule based on $1,500, if that changes in future, you got to look out for changes under the new Omnibus Act. It won't be under the PSA anymore. So that's to me a little bit strange, but it is what it is. But if you like, we can make a comment here that there should be some consistency. But it all goes back to the fundamental point that we were discussing earlier, that why have a separate act when you can fall it under the PSA. Okay. Next, the issue is on TRM, technology risk management. Again, if you've been applying for, or you just applied for a license, you know how painful this can be. And it's front and center because, like it or not, technology risk is going to feature more prominently in any business within financial services that we do. Now, there are all these MES guidelines right now, the TRM guidelines, the notice on cyber hygiene, the TRM notices, and they impact on regulated activities. Now the MES is so this is a separate point from what we were discussing. So remove VASPs altogether. Now TRM, the proposals of the MES want to impose TRM guidelines whether or not the systems support regulated activity because of the interlinkages between systems. So that's one point. The other point is that they want to impose a higher penalty of up to $1 million, given that disruptions can have a wide-ranging impact on your retail investors. For instance, if there's an ATM outage, or if you're running an exchange, an approved exchange, there is a disruption in your trading system. It could impact investors. There could be a reputational cost to Singapore as well. So hence the suggestion of imposing a higher penalty. So any thoughts on that? The MES said that it referred to two other legislation to provide a comparison and of the $1 million threshold. So any thoughts on this? Meishan, your thoughts?
Thank you, Nizam. For me, the way the TRM affects tech companies such as ours is going to be huge. TRM and tech risk is front and center for us. For me, I feel, at least for now, the request for higher penalties is coming in at not a very good time. In the first place, tech risk is already hits fintech companies and blockchain companies hard. when it happens. Sometimes it's not to our control, and we already have 2 notices. The TRM notice, the 1 hour, 4 hour timelines that we need to keep to, as well as the notice of cyber hygiene. So I really don't know where this proposal to increase the penalties is coming from. Is it because MAS feels that people are not abiding with the TRM notice? I don't know. But I do know that firms try their best, at least to meet the notice requirements, and bad things happen to good people in the tech world. There is a dearth of cybersecurity specialists. It's hard to hire. So I really don't think it's very helpful for the penalty to be increased right now. If MAS wants to help the industry in the time of COVID, they should be, coming up with proposals to build the talent pool for tech risks rather than doing this. And I do know where the higher penalties come from. Chaikit, you know, right? The AML requirements, that's
Yep.
at 1 million. And it may be maximum penalty, but when you add up the penalties, it can go way above. So for me, either MAS think about, TRM light notice meant for fintech startups so that it can be properly calibrated. I do find that the 1 million threshold is really disproportionate, and we should still keep to the current 100,000 penalty that exists in the notice.
Yeah, if I can add some 2 cents here. I mean, typically, yeah, I mean, I agree with what Mason said. 1 million the quantum is not like, astronomical, but it's still excessive, in the grand scheme of things. And in most circumstances whereby a regulator wants to give itself the power to slap a higher level of penalty, it must be after some observations or some occurrence or of situations of systemic or continuous breaches, or people are sort of ignoring TRMs, and I would sort of classify these into one bucket, right? TRM, cyber hygiene, which is new, and outsourcing. You can't really do one without considering the other. I mean, to Robin's point earlier on, using of whether solutions providers or whatever, for whatever purposes, there is some element of outsourcing, whether it's immaterial or not, that's a separate question. And then it all links back to the need to ensure that as a FI, whichever regulated activity you perform, technology risk is considered in the front and the center of everything that you do. And is there any indication that the industry is actually ignoring this, that needs a heavier stick for them to use in the future? I don't see that, and so therefore that, in my view, is a little bit too extreme. Now, the second point is that, and this is also something to do with the industry as well, fintech, as what Mason mentioned. Singapore Fintech Association, have worked with MAS and worked with an audit firm to come up with, and this is non-promotional, right? I just want to bring it up because it's an industry thing, about particularly targeting this TRM guideline and people having difficulty with it, to come up with a compliance readiness checklist, that is mapped to TRM, mapped to ABS, OSPA's requirement, and so on and so forth, to give a bit of a TRM light checklist, for fintech service provider, whether is it regulatory tech or whatever, to work with traditional financial institutions to say, we are able to self-assess ourselves to say that it's sort of in compliance with TRM requirements. Now, that's what's been done like less than 2 months ago. Now, shortly after that, you come up with this thing to say, hey, the penalty on breaching of TRM extends beyond regulated activity support system is going to be $1 million. What's the message you're sending to the industry, especially on the traditional FIs who are trying to work with this service provider and say, hey, hang on a minute, now I have got a $1 million potential fine, which means that I have to do more due diligence on you, and which means that my willingness to work with a startup company will be out of the window again. So you're taking one step forward, but you're taking 2 steps back.
Yeah, excellent point, Chakit. I think we reflect that in our comments. I think the first is the necessity for this. Has there been a prevalence? And secondly, the impact on the small guys, right? The startup community.
Yeah. So I mean, if really there's a need to raise the penalties and for it to be more proportionate, I suggest that the first step MAS should take is to come up with a TRM notice that is calibrated more for fintech startups. I mean, many of us are little guys. We all start little. And from the get-go to expect everybody, a startup, to meet the full notice requirements with a 1 million penalty, potential penalty, I find that it's very disproportionate. So some things need to be put in place first.
Just to put things in perspective as well, right? I mean, when the whole concept of the TRM guidelines being guidelines is that it's meant to facilitate departures, so long as you can justify departures from some parts of it. So it seems a bit incongruous when you slap such a big penalty when you should have a very flexible framework on TRM. Sorry, Azman, you wanted to say something?
No, it's just the second point there that you have on your slide troubles me a little bit in terms of, obviously, I agree fully with the panelists in terms of the higher penalty should be reconsidered. But in terms of the fact that MAS can impose TRM guidelines to currently entities that do not have to comply with it because of the fact that they may potentially be supporting some other regulated activity, whether they are aware of it or not. This could be potentially problematic in terms of, how that's going to be implemented, rolled out, and how does it going to be expected of those people to understand, when would this be applicable?
Okay, sorry, I'm just conscious of the time. Kevin, poll master, the last poll question for this session, can you put it up? It's just to follow up on what we've been discussing. Do people think that the 1 million maximum fine is appropriate, too high, or too low? So cast your vote away.
I guess it's good for the cybersecurity,
I hope,
insurance industry, right?
There are folks who voted appropriate.
I don't think the insurance covers fines, Robin.
True.
It covers the downtime litigation. But will it cover?
You should start an insurtech company that provides coverage for fines.
No, you can insure for all you want. That means the premium will be super expensive.
Yeah, exactly. It's all about pricing it correctly. So, Kevin,
but I think on the more serious note is that this may potentially again deepen the mentality of FIs or existing regulated entity to transfer or pass on the cost of higher penalty onto service providers, which I don't think is the intended consequence.
Oh, okay. So this is the strongest response we have, that people think is too high.
But I'm surprised there are people saying too low.
Yeah, I wonder how much is considered necessary. Anyway,
this affects all of us who use tech.
No, but if you're an aggrieved customer, you've been trading on a bank, and there are local bank ATM networks that have gone down, and I think it's quite frustrating as well. Okay, so the next point and the last point, I don't think we're going to have very much discussion on that, is on dispute resolution schemes. So we've got FIDRAC, the Financial Institution Dispute Resolution Center. As one example of a DRS, the idea is they provide avenues for people with disputes with FIs, and it's a very cost-efficient way of resolving it rather than going to the courts, which are expensive and might not be efficient. So the proposal is to provide statutory liability for the mediators or adjudicators and to align with the current approach for courts, for instance. So there'll be statutory protection. I don't think anybody is going to quarrel with it. If there are, let us know now or forever hold your peace. I don't think we're going to discuss this very much. Okay, so in effect, we are closing the session proper. So we'll distill some of the comments that we've gotten in a set of submissions to the MES. So I think we will publish this, right, Kevin? So for those of you who are interested, write into us, and we'll I think
yes, that's right. I will publish the
for the
email.
members at least. Yes.
Yes. After this, I'll just show the slide. Yep.
Okay. Yeah. So if you have any further questions arising from this, drop us a note. But If not, please join me in thanking the excellent.
Sorry, Nizam, before that, just to obviously these are consultation that the MAS expect us to obviously provide some feedback. So in terms of arising from the next steps, obviously, you will be collating some of these responses.
Yes.
For feedback to MAS.
We will be collating these,
Yeah.
we'll circulate to the panel members for sure. But if anyone's interested to have a look at it as well, let us know. I think Kevin just kindly flashed the email address for that. Whether you have further inputs or if you want a request for a copy of the submission.
Yep, that'll be good. I think feel free to ask the questions. I think everybody is ready after that. I mean, after today's session, I think it will take some time for people to internalize, you know, the wealth of information shared today, and to think about how it's going to impact them. So I think if you have any questions, send over here. If you have any questions that you wish that, you know, MS will take note of your questions once we have compiled, send it here as well, because I think we are going to engage with MS directly, right? So it's
Is
not
there
just
a timeline for this, Kevin?
Yeah, it's about 10 days time, I think.
or something like that. I think the deadline is 20th.
That's right. That's right. So I think
we'll get a draft circulated, Osman.
Exactly. We need to have those quickly, and then I think once it's sent, right, eventually, as per how it happened for the rest of the consultation paper, there will be potential meetings and all that, but that is going to be fronted by the association with the subcommittee, right? So I think it's definitely I would encourage you to send your question over to us, because we will be a very good forum to engage with MES directly, right? So as the association, yeah.
Fantastic.
Okay. Thank you.
Thank you.
All right. Stay safe.
Thank you, everyone, for attending. And yes, have a good day. Thank you. Bye-bye.
Thank you. Bye.
Thanks, guys.